This is your immigration news update from the lawyers at Hacking Immigration Law, LLC. New CDC guidelines on people entering and exiting the United States when it comes to COVID. On June 12, 2022, the CDC, the Center for Disease Control, announced that it will no longer require air passengers traveling from a foreign country to the United States to show a negative COVID-19 viral test or documentation of recovery from COVID-19 before they board their flight. Individuals must be fully vaccinated with the primary series of an accepted COVID-19 vaccine to travel to the United States by plane if they are a non-U.S. citizen, non-U.S. immigrant, which means they're not a citizen, national, or lawful permanent resident, or traveling to the United States on an immigrant visa. Only limited exceptions apply. Our next story. The Deferred Action for Childhood Arrivals program is now 10 years old. On the 10th anniversary, Republican donors and business leaders made clear that protecting dreamers would help ease the nation's shortages, reduce food prices, and create jobs for all. The Deferred Action for Childhood Arrivals program allows young people who were brought to the United States as children and who were entering the United States without inspection to obtain work authorization and to keep themselves from being deported. The program has led to thousands of young people being able to join the workforce, to get college educations, and to contribute mightily to society. The program, though, was just an act of the president. It did not involve Congress, and it is not any formal statute or law. Many have called for DACA's provisions to be incorporated into the law, but that has not happened so far. Because Congress has failed to act, the program remains in limbo and could be dismantled by any future president. 14 donors who call themselves lifelong Republicans said that reaching a deal on immigration that provides permanent legal status to the Dreamers makes economic sense. Congress remains unlikely and unable to reach any kind of immigration deal that would garner enough Republican support to pass the Senate. This is why actions have not been taken. All legislation has stalled. Some has passed the House, but the Senate, being so closely divided, 50-50, means that the chances of DACA becoming law of the land are very unlikely. Last year, the Senate parliamentarian rejected multiple attempts from Democrats to include immigration reform in their party line social spending bill. Sometimes when you can't get a formal piece of legislation passed, members of Congress try to attach that to other bills, but the person that runs the parliamentary rules in the Senate prohibited the Democrats from doing that. Republican leaders have expressed little interest in Democrats' attempts at immigration reform. Neither party wants to give the other party the satisfaction or the credit for getting immigration reform through Congress. It is a political football that prevents these young people from getting any kind of formal status inside the United States. While a future president could definitely dismantle DACA, the DACA program itself is already under attack, as the Fifth Circuit Court of Appeals in New Orleans is set to hear oral arguments next month on whether the program is even legal. With Republicans expected to take the House next year, the politics of granting Dreamers a path to legal status could get a whole lot harder come 2023, not easier. At a time of record inflation, very low unemployment, the idea of allowing Dreamers to get full-time legal status in the United States and for overall immigration reform seems to be a no-brainer. Increasing the supply of legal workers inside the United States would help stabilize the economy and lead to lower inflation. Time will tell whether the members of Congress can get their act together to provide protection for the Dreamers and for immigration reform overall. Next up, the Department of Homeland Security resumes the Cuban Family Reunification Parole Program as well as the Haitian Family Reunification Parole Program. The United States is taking a series of measures to increase support for the Cuban and Haitian people in line with our nation's interests. Both Cuban and Haitian people are confronting a humanitarian crisis, and our policy now focuses on empowering people to help them create a future free from repression and economic suffering. The Department of Homeland Security hopes to achieve this by resuming the Cuban Family Reunification Parole Program. The CFRP allows certain eligible U.S. citizens and lawful permanent residents to apply for parole for their family members in Cuba. If approved for parole, these family members may come to the United States before their immigrant visa priority dates become current. Once in the United States, CFRP program beneficiaries may apply for work authorization while they wait to apply for lawful permanent resident status. The United States will initiate the resumption of operations for the CFRP program this summer. Homeland Security also plans to resume and increase participation in the Haitian Family Reunification Parole Program. The HFRP enables family members who are approved for parole to come to the United States before their immigrant visa priority dates become current. Once in the United States, HFRP program beneficiaries may apply for work authorization as well while they wait to apply for lawful permanent resident status. The United States will initiate the resumption of operations for the HFRP program this fall. To be eligible for the Cuban Parole program, you have to either be a U.S. citizen or a lawful permanent resident. You have to have an approved Form I-130 petition for alien relative for a Cuban family member. An immigrant visa must not yet be available for your relative, and you must have received an invitation from the Department of State's National Visa Center to participate in the CFRP program. That is who may sponsor a family member through the Cuban Parole program. To be eligible, that beneficiary must be a Cuban national living in Cuba and have a petitioner who has been invited to participate in the CFRP program. When it comes to the Haitian Parole program eligibility, you have to be a U.S. citizen or lawful permanent resident, which means you have a green card. You must have filed a Form I-130 petition for alien relative for a Haitian family member, and it must have been approved by USCIS on or before December 18th, 2014. An immigrant visa must not yet be available for your relative, and you too must have received an invitation from the Department of State's National Visa Center to participate in the HFRP program. For our last story, the Supreme Court decided against issuing a ruling on whether or not Republican-led states have the authority to defend a rule that was initiated by former President Donald Trump seeking to restrict immigration benefits for individuals deemed likely to seek government aid, the so-called public charge rule. More than a dozen Republican-led states in the case sought to join a lawsuit and defend the so-called public charge rule since the Biden administration had declined to do so. But a federal appeals court had blocked the states from joining the lawsuit. The High Court agreed to decide that procedural issue, not the merits of the immigration rule. The justices heard oral argument in February, but the court recently dismissed the case as incorrectly granted, which lets the federal appeals court decision stand. This immigration rule, finalized in 2019 and rescinded last year by the Biden administration, allowed immigration officers to deny green cards to immigrants found likely to need public benefits in the future based on a greatly expanded criteria. Officers would make those determinations by evaluating applicants' past usage of certain benefit programs, as well as their health and education levels, as well as other factors. Critics of the rule argued it discouraged immigrants from using needed social services for fear of immigration repercussions. After President Joe Biden took office, his administration decided to not defend that rule in court anymore and voluntarily dismiss those appeals. They also rescinded the rule through court settlements. Arizona, Texas, and other states then asked the U.S. Court of Appeals for the Ninth Circuit if they could join the case to defend the rule instead. They claimed the Biden administration's legal maneuvering had allowed it to wipe out the immigration policy while skirting administrative requirements. The Biden administration stopped enforcing the policy in March of 2021. Thanks for tuning in. We hope you found this helpful. If you have any questions or need to get a hold of us, feel free to give us a call at 314-961-8200. You can email us at info@hackingimmigrationlaw.com. Please join us in our Facebook group. It's called Immigrant Home. We have thousands of immigrants in there trading information every single day. If you'd like to subscribe to our YouTube channel, we would love to have you. And then don't forget that we have our Immigration Answer Show 3 or 4 days a week, where you can come on and ask any immigration law related question that you like for free. Thanks a lot, and we'll see you next time.